Hi everyone, this is Mr. Fukowski. Today we're going to go through what we would be doing today in class, but of course in a much more abbreviated format. So please consult number 1 and 2 under the procedure, identifying which court system and looking at the PowerPoint. Number 4 and 5 here we'll do tomorrow, but also make sure that you're plugging away with your summative review questions, and also make sure that your outlines are complete for tomorrow's reading check. So please have that ready for tomorrow. So let's get into the notes right now. They shouldn't take too long, and then you'll be on your merry way. So in terms of PowerPoint, the federal court system, part 3, let's take a look at that. Now, in the judicial system, there are two types of cases. You have criminal law, and then you have civil law. When you have criminal law, you have committed some crime, and there's going to be some punishment if you're found guilty of that, whether that be incarceration, or if you've murdered someone, and let's say you're in the South, you might be eligible for the death penalty. And of course, the prosecutor is going to be involved in criminal law cases, and the proof has to be beyond a reasonable doubt. So the burden there for criminal cases is much bigger compared to civil law, in which this typically just involves two private parties, and the end result, the verdict, comes out in terms of compensation typically. So if you're suing Johnny for running you over with his car, you're going to be suing, let's say, for $100,000, and if you're found, that's supposed to be the compensation by the jury, then you'll receive that. So it typically involves an injured person as the plaintiff in some way or another. The standard for proof is just a preponderance of evidence. It's much less compared to criminal law, and that makes sense because if you're going to put somebody in jail, you want to make sure that you're putting a person who actually committed the crime, the correct person, because putting someone in jail is a lot worse than having somebody pay money that can always be given back. And what I thought of as fascinating is that the United States government is involved either as a plaintiff or defendant in more than 2/3 of cases brought to the federal court. More than 2/3 involves the U.S. government in federal court. I mean, that is an astronomically high number. So that just shows you, whether that's in criminal law or whether that's just civil law. People are suing the government all the time, whether it's just policy-based or injury-based, or the United States government just maybe in turn actually suing a private corporation for violating, let's say, EPA standards for pollution. So the United States government is always involved in the judicial system typically. So participants, of course, you have the plaintiff, you have the defendant, and you have the jury. Of course, those are the easy people within the judicial system. One thing that's important to take note of is the concept of standing to sue. Not everyone has the right to sue. You have to have a serious interest in the case. You can't just say, well, this could affect me down the road. No, you actually have to have a direct injury from one party or another. So if you don't have that, then you don't have standing to sue. Therefore, you can't bring a case to court. Another important point is that a case has to be deemed justiciable. If it's not, that means this particular case cannot be settled through a matter of law. So, for example, if a citizen were going to sue Congress about them funding a particular social program, they couldn't, because what law could decide that? Because that's based upon political ideology. Also, Congress, if they came up with a particular piece of legislation that hasn't been become a law yet, can't just say, hey, Supreme Court, or hey, federal court, how would you rule on this hypothetical law? No, this actually has to be a real law. It can't be hypothetical. So keep that in mind. So a very important vocab word here. Now, of course, interest groups are a major participant in the judicial system. Of course, as we know from our previous study of interest groups, such as the NAACP, they are important in using the courts as a last means to change policy, because remember, the judicial system, just like the executive and legislative branches, they are policy making institutions. Without a doubt, the Supreme Court and the overall judicial system is a policy making institution. So In this case, the NAACP and the Brown v. Board of Education will seek out litigants who best represent the cause that they support. So in this case, you have this young female litigant who is utilized in the Brown v. Board of Education to make their case and represented millions of other African Americans in stating that segregation was illegal in public schools, and it worked fairly well. Now, interest groups, as we know, also have another means of influencing the courts, and that's through amicus curiae briefs, which, of course, we know literally translates to friend of the court. Now, remember that just because you can translate it, from Latin to English, you actually have to be able to explain what it means. So, in this case, when you file these briefs, the point is to provide the court with additional information that may not have been contained in the original briefs with the formal parties involved. So you have outside interest groups, outside parties trying to influence the courts. Now, attorneys are a huge part of our court system, as you probably know. More than 800,000 lawyers in the United States today. Now, everyone, of course, is entitled to a lawyer, and that's stated in the Sixth Amendment of the U.S. Constitution. However, what happens if you can't afford a lawyer? Well, this brings about public defenders in the case of Gideon v. Wainwright, that everyone, regardless of income or being able to afford a lawyer, is entitled to one. So if you can't afford one, you get a public defender. Now, there are organizations such as the Legal Services Corporation, which does provide lawyers to assist the poor. Now, there's a lot of debate over the competence of public lawyers. It can be a hit or miss depending on what part of the country you live in, but typically public defenders are known for being overwhelmed and lacking the resources compared to someone who's able to hire a better attorney because they have more money. So there's a lot of debate over that, and we'll of course be getting into that in Unit 6 when we look at civil liberties. But do keep in mind that access to quality lawyers is definitely not equal, and that's a real legitimate criticism of our law system today, or legal system, I should say. But nevertheless, the government does have lawyers, and the head of the Department of Justice, which does seek out which cases to pursue and appeal and who to charge and indict, would be the Attorney General. And the head lawyer for the government that goes to the Supreme Court is known as the Solicitor General, just as information should you ever see it on an exam. So our final slide here, some of the constraints on the federal courts. Well, a lot of people might say that the federal courts are very, very strong. Well, certainly they've accumulated more power over time thanks to judicial review. But keep in mind that the Supreme Court or the federal courts can't just overturn policy. The case has to come to them. They can't actively bring a case to the court. Remember, this is a very passive court system. Cases come to them, not the other way around. And as we said before, they cannot rule on hypothetical questions and situations. That this has to be able to be settled through legal methods. If you can't, then they can't rule on it. And then the final constraint involves political questions. If there's a matter that the Constitution leaves to another branch of government, such as recognizing a foreign nation, the Supreme Court cannot rule on that because that's the power of another branch. So if it involves political questions that cannot be decided by law, it's not their place to rule. All right? So please review these notes. Please make sure your outlines are complete for tomorrow. Try to take a stab at identifying the court system involved in number one, which court system activity. There's only about 6 scenarios. And your job is to identify whether this is the state, district, appellate, and there's even one that could fall under the Supreme Court. So you can add that as a 4th option as well. Okay?